Hello everyone, welcome to the program. This is Politics Today live on Channels Television. I'm sure Kimale in Abuja. So much to talk about, just like any other day. We're in the political season, so you expect that to happen. Even on a Friday when you think that things will simmer and perhaps there isn't so much to talk about, but there are lots to talk about. But before we get into all of those matters that we'll be discussing tonight, let's check out some of your political roundup stories.
The Nigerian army has begun plans to ensure safe conduct of the 2023 general elections. According to the Chief of Army Staff, Lieutenant General Farouk Yahya, the operation code-named Operation Safe Conduct will launch soon. While speaking at an event in Abuja, the Army Chief warned senior officers and field commanders against partisan politics. Some youths in Taraba State under the name Oshibajo Youth Organization have asked Nigerians to rally round the Vice President, Professor Yemi Oshibajo, whenever he makes his intention known to join the presidential race ahead of the 2023 elections. The youth during a rally in Jalingo said there is need to shun the political tradition of electing only the aged into power, as they have seen capabilities in Professor Oshibajo. It's the first time a female will be emerging any party's governorship candidate in Ekiti State, and one of the two candidates is sending signals of readiness to take over governance in the June governorship election. She is the candidate of the Action Democratic Party and has assured that women will have their place in governance. She was speaking in Ado Ekiti while displaying her certificate of return, having emerged the party's candidate.
By the time I emerge as the governor of Ekiti State, I think the National Assembly will also sit tight and they will see it that it's not only in Nigeria that is happening, just that people like to do the same thing the archaic way they've been doing it.
A presidential aspirant under the New Nigeria People's Party, Mr. Joseph Fadori, has challenged the youth to rise and take over power from the older generation. Addressing a news conference in Abuja, he says Nigeria needs young minds who can reposition the country to be a technologically driven economy. According to him, the state of poor infrastructure in the country will be his major priority if elected President of Nigeria. A group known as the Northeast Business Community has bought the People's Democratic Party's presidential nomination form for the former Vice President Alhaji Atiku Abubakar. Receiving the form in the nation's capital, Alhaji Abubakar promised to address critical national issues, especially security. He said he's fully prepared to move Nigeria to a greater level with his wealth of experience in governance.
Our unity is threatened, like somebody said. Our economy is in the worst state of affairs since the inception of this country. Our security is a disaster.
The Deputy Governor of Benue State, Mr. Benson Abonu, has described himself as the best candidate to take over from Governor Samuel Otom come 2023. He was speaking in Abuja, where he went to pick up his nomination form at the PDP headquarters. According to him, he is in good relationship with the incumbent governor and has no doubt of his support. The African Democratic Congress says it has developed a strategic plan to rescue Nigeria from the current challenges facing the country. Addressing journalists after a meeting to the National Working Committee of the party in Abuja, the national chairman of the party, Dr. Ralph Mwosu, promised to attend to insecurity and the lack of basic infrastructure if the party wins the presidential seat. The contest for the chairmanship position of the All Progressives Congress is nearing a feverish point, with contestants returning to the National Secretariat of the party with the completed forms for the expression of interest for the office of National Chairman. Party supporters, officials and well-wishers were present at the event today.
Mr. President, abhor corruption. He hates corruption. He doesn't like corruption. So in everything we will do, even in the election that we want to do, he will want to see that equity, fairness and justice prevail.
All right, then, you have it, your political roundup stories, and you are up to date. Tonight, our conversation will begin first around the cross line between law and politics. You remember that the clause in the new Electoral Act 2022 recently signed by President Buhari, which asked, when he asked that clause should be amended. Yes, the court today ruled on that, and the Federal High Court sitting in Umar here in Abia State has ordered the Attorney General of the Federation to immediately delete Section 84, subsection 12 of the amended new electoral law. Justice Evelyn Anyadike held that the section was unconstitutional, invalid, illegal, null and void, and of no effect whatsoever, and cannot stand as it is in violation of the clear provisions of the Constitution. The section says, quote, no political appointee at any level shall be voting delegate or be voted for at a convention or congress of any political party for the purpose of the nomination of candidates for any election, end of quote. In the suit, Justice Anyadike further stated that Section 66, subsection 1F, 107, subsection 1F, 137, subsection 1F, and 182, subsection 1F of the 1999 Constitution already stipulates that appointees of government seeking to contest elections will only resign at least 30 days to the date of the election, and that any other law that mandated such appointees to resign or leave office at any time before it was unconstitutional, invalid, illegal, null and void. Let me allow you to take a listen to some of the lawyers after that, the decision of the court today.
Earlier before now, because of the rancor surrounding Section 84, subsection 12 of the Electoral Act, when our client approached the Federal High Court to determine whether Section 84, subsection 12, when read together with sections 66, 107, 137, 182 of the Constitution is not inconsistent. Now, the court agreed with our submissions, and it has just ordered that Section 84, subsection 12 of the Electoral Act is inconsistent with the rights of Nigerian citizens when read with Section 66 of the Constitution, 107, 137, 182, and now nullified Section 84, subsection 12 of the Electoral Act. And as equally has ordered the Attorney General of the Federation to delete Section 84, subsection 12 of the Electoral Act forthwith. Now, the implication of this is that it has provided a congenial atmosphere for politicking and political space for 2023.
We represent the Honorable Attorney General of the Federation as a defendant in this matter. So that's why we're here, in respect of the interpretation of Section 84.12, which the court has graciously put to rest now, as being a total nullity, being in conflict with the provisions of the Constitution. And originally, we honestly believe that it was inadvertence on the part of the National Assembly. It was a big error. And being gentlemen and distinguished senators and the members of the House, I think they will now go back and do the right thing, since the court has made pronouncement on it, and that put to rest every other issue with regards to that, so that we can move on with the national issues that are besieging us as a country and as a nation.
After the president signed the electoral bill into law last month, the president had asked the National Assembly to delete Section 84, subsection 12. I'd like you to listen to what the president said at that moment. Take a listen to him again.
Hence, it will be stretching things beyond the constitutional limit to import extraneous restriction into the Constitution on account of practical application of Section 84, subsection 12 of the bill, where political parties, conventions, and congresses were to hold earlier than 30 days to the election. Arising from the foregoing, with particular regards to the benefits of the bill, industry, time, resources, and energy committed in its passage, I hereby assent to the bill and request the National Assembly to consider immediate amendments that will bring the bill in tune with constitutionality by way of deleting section 84, subsection 12 accordingly.
You heard the president when he was asking that I will sign this law, this bill into law, but tinker with the section 84 subsection 12 because according to him there is a conflict with the constitution of Nigeria which the court has now laid to rest. But there is another angle to it. It was the debate at the Senate, at the floor of the Senate. I'd like to remind you again what the senators were saying because he's going to be instrumental to our conversation also. Take a listen because at that moment the senators struck out or voted out the request of the president. Take a listen to their debate again.
This provision has been interpreted by the executive arm of government as introducing qualification and disqualification criteria that are ultra-violating the Constitution by way of importing blanket restriction and disqualification to serving political office holders.
We don't need to be told that if we want to run for office and we are appointed into an office that we have to resign. That is a sine qua non that we don't even need to debate. Yet, here we are today in Nigeria, and people think that they can sit in an office and contest an election and become candidates and continue to sit in that office until the date of election.
No political party shall seek to disqualify anybody by importing into the process a provision for qualification or disqualification not otherwise provided for in the Constitution. It is there at the beginning. I believe that's section 84, section 84(2).
Those in favor that this bill be now read a second time, say aye. Those against say nay.
The senators voted against it. The court today says no. That's it. That clause is against the Constitution. Let's get some legal opinions on this issue tonight. We'll be looking at the implication of what the court said. I'm being joined by a renowned Nigerian constitutional lawyer, rights activist, and holds a PhD in law. He worked with a very respected rights activist, Gani Fawemi, and later became a senior advocate of Nigeria in 2010. Chief Mike Ozakame joins us tonight on the program. Thank you so much, Senior Advocate, for joining us.
Thank you.
It's good to see you.
It's like you are permanently in Abuja here now.
I've come to have a good breeze.
Wow.
Enjoy Abuja.
This is good.
Thank you so much for coming tonight.
Thank you very much.
Give us a sense of what is happening because the judge today had said there are conflicts and there are provisions already in the Constitution. Cited section 66, section 187, and a few other sections of the Constitution that this clause of section 84(12) is in conflict with. So give us a sense, can a court validly strike out a legislation by the parliament?
In fact, that is a function of the court. There is a bifurcation of powers. We call it division or separation of powers. What Adam Smith we call division of labor in his theory. In law, we call it separation of powers. That doctrine propounded by Baron de Montesquieu in 1748, that there must be separation of powers between the executive, the legislature, and the judiciary. This has been encapsulated in the Nigerian Constitution. Section 4 deals with the legislature. Section 5 deals with the executive. And Section 6 deals with the judiciary. The judiciary's job is to interpret the laws. And where in interpreting the laws, it discovers that an act of parliament or a law made by House of Assembly, even during decrees of military juntas, they will strike out that act or law or decree if they find that it is contrary to the provisions of the Constitution. And the Constitution makes it clear in Section 1, subsection 1, that this Constitution shall be supreme And then in section 1, subsection 3, it says, if any other law is contrary to the provisions of this constitution, that other law shall be null and void to the extent of the inconsistency. So it is the duty of the judiciary, the court of law, like the Federal High Court in Umuahia, as that woman did today, very courageously, to strike down any law or any act of the National Assembly that is unconstitutional. Now, there's what we call the doctrine of covering the field. The doctrine of covering the field, put in simple parlance, is that where, for example, the Constitution has made provisions for certain areas, then the National Assembly cannot come into that area again to make a law. On the other hand, if the National Assembly has made a law on a particular area, then a House of Assembly cannot also come to that area. That is why once the Constitution has made provision for something, such as the qualification for a person to go for election, the National Assembly cannot smuggle through the back door without going through the provision of section 9 of the Constitution to amend the Constitution holistically, as they are currently doing, by promulgating an act of parliament that tends to defeat or affront that constitutional provision. For the avoidance of doubt, let Nigerians hear this. The Constitution, we call it the font e origo. We call it the ground norm. I have described it many times as the Kabiyesi, that's the Oba, the Eze, and the Emir of Nigerian laws. In the hierarchy of laws, it's at the top most. So when the National Assembly was making section 84, subsection 12, in the amended Electoral Act, by saying all political appointees shall not partake, shall not vote or be voted for at congresses of political parties, it was acting ultra vires. Because the Constitution in section 65, 66, 175, 176, 182, 183 has already told us who can contest elections or who is disqualified from contesting elections. So the National Assembly cannot add or subtract. And by the way, they tried to do this before. The National Assembly had inserted section 52, subsection 3, into the amended act now. That time it was still a bill, by saying that INEC, which the Constitution has said is truly independent under section 158, are not subject to any person or other authority. The National Assembly wanted to subject INEC to the National Communication Commission by saying that in transmitting electronic results, National Assembly, the INEC should come back to the National Assembly and ask the National Communications Commission, do we have a network in that area? Which I was here. We spoke on it. I criticized it. I went against it. I wrote in torrents. I spent torrents of ink writing against it. That it was unconstitutional due to the hoopla generated by it and the rocos and Nigerians' opposition. The National Assembly was forced to withdraw that. So one would have expected, I hardly agree on many occasions with President Buhari in terms of his governance style. But this was one letter he wrote to the National Assembly that I agree with. So when he told them, please, can you remove this section?
Chief Ozakume, some people have criticized him. As soon as he said, National Assembly, please tinker with this section, he said, look, it is not your business, President, for you to tell the National Assembly what to do. Was it right for the president to have pointed it out? If you look at the different kind of bills that are available, we have executive bill, we have private bills.
Yes.
In that sense, does the suggestion or the proposition of the president fall within the premise of the possibility of amendment of any legislation in the National Assembly?
I think what the president should have done, or his handlers should have done, instead of that letter, make an executive amendment, a proposed executive amendment bill, and said to the National Assembly, we want you to amend Section 84, subsection 12, because it is not in line with the Constitution. You are bringing extraneous qualifying factors into the Constitution, whereas Section 66, subsection 1F, says that the only disqualifying thing for a public officer is that you must resign your office 30 days.
Let me read it for Nigerians.
Yes, 30 days.
Let me read it for
before any election. 30 days.
So that people can get it.
Yeah.
Because I'll bring back the Section 84, subsection 12.
Thank you.
And there is a political undertone. It is a political section of the law.
You know what?
Let me read
why I believe that it's political.
Yeah.
She won't believe you me. Each time I called the National Assembly, this 9th National Assembly, unlike the very brave 8th National Assembly, I called them Mr. Tekebao National Assembly. Why would they refuse Mr. President's budgets, with many of them borrowing ahead for generations yet unborn? Why do they always say yes, 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 like the lizard nodding his head, yes, yes, yes? Why was it this time that the National Assembly will rise up for the first time and find the voice to go against Mr. President? Because it has political undertones. I agree with you.
You pointed out Section 66, subsection 1F of the Constitution clearly states, the major conflict.
Yes.
And it says clearly here, he said, is a person employed, he was talking about disqualifications.
Yes,
he
disqualification.
said, Section 1 in the preamble of it says, no person shall be qualified for election to the Senate or the House of Representatives if, then the F says, if he is a person employed in the public service of the Federation or of any state and has not resigned, withdrawn, or retired from such employment 30 days before the date of election.
Yes, that's what the Constitution says. And in law, there's what you call the principle, put in Latin words. It says, expressio unius est exclusio ulterius. What does it mean? Say the express mentioning of one thing is the exclusion of others. The Constitution has told you clearly how a person appointed into the public service, maybe by Mr. President as a minister or by governor as a commissioner, how it can be disqualified from contesting or being contested or being voted for in an election. And that is that you must resign 30 days before that election. If you don't resign 30 days before the election, then you are disqualified. But what that Section 84, subsection 12 of the amended act was saying is that you are totally disqualified from ever contesting.
You need to resign your office 30 days before the primaries.
Yes.
For example, the window and the timeline for primaries now set by INEC is between April and June this year.
Exactly.
So that means anybody who wants to contest,
would
have resigned April in the next month.
Yes, next month, like 30 days before the time.
So let me give you an understanding. So Nigerians can have a context to get the context of what we are discussing tonight. Should this law subsist if today's judgment does not come? There are insinuations in some quarters that these are some of the personalities in which this law was meant to attack or was going to affect.
Okay.
So take a look at them on your screen. One of them, some of them are majorly the ministers in President Buhari's cabinet. Someone like Rotimi Amechi, whom it's been said that he has ambition to run for president. Someone like Godswill Akpabio, who has been said also to have a presidential ambition. And also someone like Chris Ngige, the Minister of Labour, who is also been said in some quarters that he has presidential ambition. Or the likes of Abubakar Malami, the AGF and the Attorney General of the Federation, who talks also there that he may be running for the governor of Kebbi State, his home state. So these are the possibilities of those whom this law will directly affect. It then means that if the Section 84 subsection 12 subsists, these four men that I've mentioned will have to resign their office, isn't it?
That's what it meant.
But
if the court had not struck down that section today, the court has spoken and it is finished. It is finished. Once the court has spoken, except the people, the defendants in that case, appeal the judgment and the Court of Appeal sets aside that judgment, and it further goes to the Supreme Court, the final Court of Appeal, and it sets it aside, that judgment remains extant, subsisting, valid, and constitutional. In other words, as we speak, Sheon, there is no longer subsection 12 in section 84 of the Constitution. It is dead. It's like I always say, it's as dead as dodo. It does not exist. It's extinct.
Except if there is an appeal.
If there's an appeal and the appeal court reverses, not just an appeal, the appeal court has to reverse it. When it reverses it, then it's not there.
Let me bring to your notice the section 318. When the interpretation or the definition of the Constitution as to who is a public servant or a political appointee. Do you think, because some of the drafters of the law will tell you that some of in the definition of the political appointees as captured in section 318, that this section of the Electoral Act is not wrong in any way?
The section is wrong. It's wrong. I mean, these are public officers. Public officers. A minister is a public officer within the meaning of section 157, I think, or 158 of the Constitution, just like commissioners under section 192, 193 of the Constitution. They are public officers. A public officer can be hired and fired at any time. Central Bank governor, for example, is a public officer. Now, these are people who are different from pensionable cadres of employment, like civil servants. A civil servant has a tenure within which he must be in office until he gets to the age of 60 or 55, or after serving 30 or 35 years, depending on the laws governing them. But when you say public servant, you can be hired today and fired tomorrow. Because you can be reappointed.
A public servant, that's what the contemplation of the Constitution gave, not political appointee, as the Electoral Act appointed.
Yeah, political appointees are public servants because they are drawing money. In fact, there are some decisions by the Supreme Court that people who draw money from the public coffers.
But that's not what the Constitution said specifically. Section 318.
What does it say?
No, section 318 speaks about public servant.
Yes.
But the Electoral Act 8412 talks about political appointee. These are different terminologies.
Political appointees are public servants. That's what I'm telling you. It's the same 6.5 dozen. It's the same Romeo and Juliet. It's the same akara ball, beans, and momoy. There's no difference. That's what I'm telling you.
So, I mean, again, I was calling for the faces of those whom if the judgment of today had not come, these are some of the faces which may be affected. There you have them on your screen. These men would have had their ambition killed and would have died and would have been dead as dodo, just like the senior advocate has said. But we take a break, everyone. When we come back, more from Chief Mike Ozekame on the issue of the law, what the Electoral Act says, and the Constitution. Is there a conflict? And in this case, what will happen? But we'll also talk about the legal scare that APC had, and well, it does look like there's a reprieve now, as there was a vacation of that court order, which will have effectively stopped the National Convention of the APC, slated for the 26th of March 2022. We'll talk about that also when we return from this break, everyone. Join us again. Expert in some aspects of law, there is a reason, and tonight that's the reason why we brought Chief Mike Ozekame, constitutional lawyer and a renowned rights activist in Nigeria. It's debated on several aspects of the law, contentious one, controversial one, such as what we are having today. And I'm getting a lot of reactions on what the stance of the law is, and earlier on we were showing you the faces of those who might be affected by the section 8412 of the Electoral Act if it subsists. But now there are a lot of definitions now. There are inferences. Politicians know this law like the back of their hands. Chris Ngige, Abubakar Malami, Godswill Akpabio, Rotimi Amechi. These ambitions of these gentlemen will have been dead as dodo, just like you said. But I mean, In the final analysis, SN, give us an implication of what this means for the political parties.
What it means for the political parties, is that it's going to make it more contentious. People whom some people or some politicians may have thought have been edged out will now come in. The political space needs to be widened, broadened, deepened. I don't believe in circumscription. That was why I was against the circumscription of certain people not being allowed to participate. Open the floodgate. Let everyone participate. In fact, introduce independent candidacy so that people who do not even want to belong to these politicians, these political parties, can go and contest on their own if they feel they are popular. But for now, those, you can call it a reprieve for the politicians who you said may probably have been targeted. Because for once, I was surprised that the National Assembly could rise up so spontaneously to say no to Mr. President. I can't remember any time in the last 5 years that National Assembly ever said no to Mr. President. And Mr. President was making a good suggestion to say, look at section 66(1)(f) of the Constitution. It says political appointees and everybody, public officer, they can resign 30 minutes and 30 days before an election. Why are you now saying they must resign now, that if, in fact, they are banned? So that was what he went against, and that was why I agreed with him.
Let me have asked you, let me make a reference here. You're aware of the case between Dada versus Adeyeye, where the court was giving a definition of what a public service of a state is. Yeah. I think relevant, similar thing was happening at the time when the court ruled in this matter, and the qualification for election into Senate or House of Reps. And the definition as given by the court is totally different from the political appointee. If you look at section 318, if you look at it here, what the Constitution refers to as public service of a state or public service of the Federation looks like it's a different definition from political appointee. That's what some other lawyers will argue.
Yeah, it's an argument. There are many cases for and against, even up to the Supreme Court level, as to, for example, whether a governor is a public servant. I've contested these cases now and again up to the Supreme Court. There are many. Some people believe that political appointees are not public servants because they have not been employed to serve in the public service of the Federation or of a state. They are therefore not public servants. There are some other cases that say no, political appointees are public servants because they draw money from the national till or the state treasury. And because they are paid from there, they are public servants. It's a controversial area. But what we have had today is a judge seeing these political appointees as public servants who are covered by section 66, subsection 1F. And like I said, until that judgment,
there's another angle to this.
Until that judgment is set aside on appeal, it stands. It remains the judgment.
It sounds repealed.
It has repealed section 84, subsection 12
but
of
now,
the Electoral Act.
If you look at it again, the 8412 talks about standing for primaries or convention of a party. But section 66 is talking about INEC conducted elections. Not political party conducted
The political party conducted elections must be observed by INEC. If you go and look at section 82
it's not clearly stated at the Constitution.
No. In section 82, INEC, for example, must be present during those elections being conducted. Otherwise, they will be null and void. That was what happened to APC in 2015. INEC said we didn't observe the conduct of the primary elections in Zamfara. That was how the doctrine of, I invoked the doctrine of consequential relief for Governor Matawale, who was then in PDP, to be made governor, because he was the person who had the plurality of votes and spread in the local government areas of Zamfara State, because it was an internal quarrel within the APC, between the Kabiru Marafa group, senator, and the Governor Yari group. And because they did not hold valid primary elections, the Supreme Court declared that the votes that were cast at that primary by a hurriedly cobbled together primary election group by the Governor Yari were votes that were wasted. So INEC must watch and observe this convention or Congress election, otherwise they will be invalid. And that is why INEC had also warned that, look, you must give us 30 days notice.
All right, let's wrap up
before
quickly.
that. And if they don't give that 30 days notice, as INEC told them, then the APC convention elections will also be null and void. Any aggrieved member will just go to court and nullify them.
Let's wrap up in 30 seconds so that we move into another issue. Because there is the argument continues that the section 8412 talks about the Constitution provides for public service, and section 84 provides for political appointee. I know this will be debated in the appeal court.
Yes, it's a matter of debate. Yes, it's a matter of debate.
But what does this talk about constitutional law in Nigeria?
Yeah, the constitutional law itself is a vast field. It's like the story of the bat who will come to the animal kingdom and say, I'm one of you, because I have mammary glands, I have canines, and I have pineal. Then it will live there and go to the bird's kingdom and say, I'm one of you. The bird said, no, you are not one of us. You are just coming from animal kingdom. He said, let us try. Let's fly together. And if we fly like any of them. So constitutional law is very vast.
So this stands, and that 8412 stands repealed.
It stands repealed.
Thank you so much.
And extinct as we speak.
Yeah.
Yeah.
There are a lot of reactions coming in on what you have said tonight.
Yes.
But it's good for you to have given us this legal opinion and your perspectives on this. Chief Mark Ozekame, thank you so much for coming.
I appreciate you.
Thank you so much. I appreciate it.
It's well with you.
Yes.
Thank you.
Now, we switch gears now, and it looks so much that there's a breather for the ruling All Progressives Congress APC, as today a high court in the Federal Capital Territory of City vacated an order stopping the National Convention of the All Progressives Congress APC billed for the 26th of March. Justice Bello Kawu gave the judgment, arguing that a political party cannot be sued by its member. The judge relied on recent Supreme Court judgment, Aguma versus APC, to conclude his ruling. The ruling followed the twist in the leadership of the ruling party as the plans for the convention. Meanwhile, there are other developments emerging indicating that Senator Akpan Uduede remains the National Secretary of the APC, against reports that he may be on his way out, or in fact he's been ousted by some forces in the party. He was seeing earlier today a meeting with Governor Buni, and well, let's get the conversation started and look at the implication of the vacation of the court order, which would have would have killed the convention of the 26th of March. I'm being joined by a lawyer and a member of the legal subcommittee of the APC ahead of the National Convention. Mr. Sunusi Musa joins us here in our Abuja studio. Thank you so much, Mr. Musa, for coming.
Thank you very much, sir.
What does this mean for your party? If the vacation didn't happen, what would have happened to the March 26th convention?
As a party that is committed to the rule of law, we couldn't have gone on with the convention, because a court order, whether wrongly or rightly, is a court order. But happily, my Lord in his wisdom has seen reason that that court order ought not to be given in the first place, and he has vacated it, which now set the tone, and that the field is clear now that APC is going to hold its convention on 26th of this month, God willing.
But that's just one. I mean, if the things that we hear are correct, that over 200 court orders are lying in wait ahead of the convention.
I doubt that will be the truth. Look, I don't think Nigerian court will be that reckless to be given court orders anyway. Otherwise, because it will lead to chaos. Because to the best of my knowledge, as a member of the legal committee, the APC has not been served with any court process anywhere apart from this one. that is challenging the conduct of the convention. So, and I don't believe there is any court in Nigeria that will go behind the APC and give a court order that will affect it. That would be contrary to the provision of the
Constitution. You imagine that is the rational thing to do. But the rational things are happening. There was a court order from November last year that the party just got the win of just recently.
Yes, but you know, I think what happened that was more of miscommunication with the lawyer that was representing the party. Look, the APC legal department is handling more than 300 cases presently. So it's quite, you know, the human nature for once they get report, and I know the legal department gets report from various lawyers on cases that are going on. Okay, if a situation like this one, the lawyer failed to file the report, I mean, they're handling such number of cases, you don't expect them that some human factor must be given in. So my last check with the legal department, there is no any court order or any process that is served from any court in Nigeria to the APC that has to do with the challenging the conduct of the convention. That is the only one. And APC immediately briefed a lawyer to conduct the case. Unfortunately, maybe he too, work was too much for him. He did not communicate to APC on time. Otherwise, APC couldn't have allowed something to have been there for that long without taking any time. But thank God that we got wind of it, action has been taken.
We understand that the party recruited recently some senior lawyers for the case of unforeseen court orders that may emerge against the convention.
Look, the party has always been with senior lawyers. Mark, you, even in the main convention caretaker committee, we have a senior advocate who was a former director general of the Nigerian Law School. So, and we have so many senior advocates that are members of this party. So, always the party has such a retinue of good lawyers that sits and critically examines them. But of course, it's in order when you have such a thing to be ready to have a committee that will respond quickly to such issues. And I doubt if at this time any judge will listen to any litigant to give such court order, because I mean the NJC have consistently been warning them that the judges should be wary in delving into political issues that may likely affect the polity. Right. I doubt if any judge.
Since you have insight into what is happening in the party, give us a sense. There is a picture of which emerged earlier today, a meeting between Governor Buni and Senator Akman Udwe there, which I like it because what we are hearing is that there was a vote of no confidence on the man who has stood his ground, we understand, not signing what would have put a paid to the existence of Governor Buni as the caretaker chairman. What is the position of things right now? Because there are talks that maybe he has been ousted as the national secretary. Give us a sense of what is happening.
Okay. I don't want to comment on the issues that has to do with the caretaker committee, but let me say it this way. Assuming that like you said, vote of no confidence has been passed. The implication of the vote of no confidence does not mean that Senator Akpan Udwe cannot meet with Maimala. He cannot even meet with any member of the CCPC.
But can
because he's still a member of the party.
CCC can even exist without the national secretary? The national secretary is the backbone of the administrative structure of the party.
This is a committee, mark you, and if by the provision of
national administration of the party,
yes, but the committee can appoint another person. That is if he's
removed. Is when the neck sits. Can you replace any member of the caretaker
by the provision of the APC constitution? Normally, NEC gives NWC power to act on his behalf, and when there is a NEC meeting, they ratify such decision taken. Either they ratify or they reject them. because the day-to-day running of the affairs of the party is in the hand of the APC. But these are issues like when His Excellency Maimala comes back, said that they are going to be resolved. And in any way, I don't think when people, you know, the press somehow have not been fair to us. His Excellency, the Governor of Niger State, never said Maimala was removed. He said he was acting chairman. That was what he said. So, in any way, if like you said, that he refused to sign any document that will seal the fate of Governor Maimala, if it is true that a vote of no confidence has been passed on him, something could have been passed on His Excellency Maimala.
Okay.
That shows that there was not any problem, actually.
Let me show you this. This has also emerged on one of the platforms of some of the governors. It was reported to have been a message sent by Governor Nasir El-Rufai of Kaduna State. Let me read that message. It was said to have been a WhatsApp message, and now made public. It's everywhere. It's in the public domain, and something that looks like the governor not really happy with the state of affairs in the party. Governor El-Rufai was said to have written to some of his colleagues to say that loyalty begets loyalty. Deception begets mistrust, betrayal begets revolt, ineptness, greed, and selfishness threaten to destroy what has been built over nearly a decade by those who did not even know how this party was put together. Let's restate that I'm done with this charade unless concrete, honest, and transparent steps are taken to implement our agreed plans under a leadership we trusted. It does look to me like the governor is threatening to leave the party. Does it look like that to you?
Well, the governor has a spokesperson. If it is from the governor, his spokesperson could have said it. And the Governor El-Rufai, I know, is outspoken, somebody who doesn't need anybody to speak for him. If really he wants to say something like that, he could have come out to say it. So
you don't trust what I've just put out now?
Of course, I can't.
Before I put it out, you don't trust that this has been confirmed?
No. Governor El-Rufai is such a...
No, I'm saying to you, Mr. Sunisi Musa, that on this platform, I've put something out there, and you doubt that it's
no, it's look, you said, I'm not doubting you. I said, if El-Rufai said it, you have the right to believe it. I also have the right not to believe it unless I hear it from the...
But that's what I'm putting out to you.
But
it shows some level of frustration about what is happening in your party.
Look, let me tell you one thing. In life,
it talks about
look, let me tell you one thing.
It talks about a lot of things that is happening in the party, and those who are planning to bring down the party.
Showing it will be, I will not be telling lies if I said you can't be 100% satisfied with what is going on in Channels Television as an organization. There is no way you can be 100% satisfied. There are things that have been done here that you are not satisfied with.
No.
But that does not mean you are not in the system.
The contexts are different. I mean, these are apples and oranges.
And there's an organization.
We're talking about a governor who is obviously coming out and saying that, look, what's happening in the party. If nothing changes, that's
what I'm saying. There are 36 governors. We have about 24 governors in APC. So definitely there is no way all of them will at all time be satisfied with it or what is going on. And it is normal for somebody to express his frustration. But that does not mean he's not a member of the party, and that does not mean he doesn't love the party. It's out of his sincere love for the party that he's saying his frustration.
Thank you so much, Mr. Sunisi, for coming to clarify some of these legal issues for us. But before we close on the program, let's tell you some of the updates coming on the case involving the former governor of Anambra State, Willie Obiano, who was said to have been arrested in Lagos and brought to Abuja at the FCC office. We're getting information now that it was the reasons behind the arrest was for alleged misappropriation of public funds, including 5 billion naira Shuopi and 37 billion naira security vote, which was withdrawn in cash, Part of the funds were also allegedly diverted to finance political activities in the state. We're getting some information relating to the reasons why former Governor Willie Obiano was picked up by the EFCC. We understand that it might be connected to an alleged misappropriation of public funds, including 5 billion naira Sure-P funds and 37 billion security vote, which was withdrawn in cash, according to sources in the EFCC. And part of the funds were also said to have been allegedly diverted to finance political activities in the state. Also, before we go, we're getting reactions now from the Attorney General of the Federation on the decision of the Federal High Court in Umahia. And the Attorney General is saying that accordingly, it will give effect to the court judgment in line with the dictates of the law and the spirit of the judgment. And the statement coming from the Attorney General office is saying that the judgment of the court will be recognized by the government printers in printing the Electoral Act. The act will be gazetted, factoring the effect of the judgment into consideration and deleting the constitutionally offensive provision accordingly. That's the statement coming from the office of the Attorney General of the Federation. But that's how we close the program today, everyone. Many thanks for watching. I'm Sean Okimale. Bye for now.